The NPA head Shaun Abrahams says that there is no substance to the claims that he would not prefer charges against President Jacob Zuma. And the North Gauteng High Court says Zuma appointed Abrahams because he was less likely to charge the president than his predecessor Mxolisi Nxasana. Meanwhile, Zuma is questioning the legal standing of the court ruling that strips him of the power to appoint an NPA head. President Zuma says the ruling will create a bad precedent of two people exercising presidential powers at the same time. And here's how the NPA says the court ruling is flawed. It says that there's no basis for claims that Abrahams won't prefer charges against President Jacob Zuma. And the error in Nxasana's golden handshake has no bearing on Abrahams' appointment. Unfair for the court to rule that Abraham sided with President Zuma on Nxasana's axing.
We believe that Shaun Abrahams is a victim of circumstances in this matter. He was not party to the settlement agreement between the president and Nxasana. He was appointed to a vacant position. He succeeded Dr. Ranaide, who was acting in that position for his permanent appointment. On those bases, we firmly believe that the court erred in setting aside his appointment on the basis that there was no vacancy.
I think this is an absurd tactical move. Why? Because even though there may be a legitimate basis in theory to challenge the move of executive powers from one office to another when it is prescribed in the Constitution, it in this instance is devoid of the multifaceted constitutional crisis that the continued occupation of the presidential office by somebody who has got a lot to answer in terms of illegally, and also the person that the president needs to appoint at this stage also faces a decision on whether or not to prosecute the president. So this is a crisis case situation, and you just don't understand why the president actually feels strongly that he must play the role here of the appointment.
And yesterday, President Jacob Zuma also appealed the ruling. He challenged the court's view that Deputy President Cyril Ramaphosa must appoint the NDPP, arguing that there cannot be two presidents in one country. And here's what President Zuma's lawyers argued in court papers. They say the court erred in law by finding that President Zuma was unable to perform his powers as president to appoint the NPA head, but at the same time is able to perform his other functions. The judgment effectively made it constitutionally permissible to have two presidents in South Africa, both exercising presidential powers. We're joined in studio by Kim Heller and Papano Pasha, political analyst. Ladies, thank you so much for joining us. What a joy to have a girls-only panel for a change, and I know I'm being sexist. But just in terms of the developments now, and this of course stems from the 783 charges. We've been on this for over 10 years or so. President Jacob Zuma appealing various judgments, and this particular one saying that as a president, your entire executive function cannot be nitpicked as to which one you can perform at any given time. The judge saying that he's conflicted. Kim, what do you make out of this particular review from Zuma or appeal?
Yes, I agree with him. I think that we are very selective about what we're accepting in terms of legal best practice, and we're cherry picking what we like and rejecting what we don't like. And I think people are so desperate to find the president culpable, despite the fact that he's won so many court cases, that they are working on a body of assumptions and allegations rather than evidence. I mean, even as far as Shaun Abrahams is concerned, if you look at evidence versus allegation, it looks like he's pursuing the matter with great vigor. And he's got the witnesses in place, I think all 218, and he's also got all the legal processes lined up. So it's all systems go, and yet he's being portrayed as somebody who's stalling on this process, which is not true. And I think it's quite dangerous how we're using the legal system for political ends rather than as a true instrument of democracy in this country as it should be.
Do you think that is more politicking than a case of what the popular lexicon has been, that it is a deliberate attempt for Jacob Zuma not to face charges or go to jail, and that Shaun Abrahams has been very instrumental in ensuring his protection?
I think one of the things about the law is that it's not necessarily subjective. You know, it's not about hearsay or what we would think. But I think we must actually look at what the law itself says, or what the judgment in particular referred to. One of the things that the judgment spoke to is the issue of conflict. But, you know, you spoke of the 783 charges and the fact that, you know, the president might want to stall the process. But I think the contradiction in all of this is that the judge or the judges were actually appointed by this conflicted president. You know, the executive itself. The deputy president in 2012 was appointed by this conflicted president. So I think that's you know, that is where some of these challenges lie in terms of interpreting the law itself. Was the president, or is the president suddenly conflicted with Shaun Abrahams? When he became president, for example, in 2008, the charges were there, by the way. The charges, I think, were drawn up in 2006, 2005. So when the president became, when Jacob Zuma became president in 2008, one would then say that at that point he was conflicted. Now, the judge himself, who was appointed by President Zuma, would it not make sense that the judge would then reflect on the judgment that was made on his own appointment as a judge? You know, I'm just saying that, you know, that's where some of this, you know, when you look at the issues from, you know, another angle, one would actually say that whether it's a question
I think there's merit in there, and let's explore it a little bit in the sense that the appointment of a public protector, for example, a Chief Justice, Mogoeng, initially there had been questions and suspicions on whether they are competent enough and independent for that matter, until in the case of the erstwhile public protector, the Nkandla matter then became more prolific, and also similarly with the Chief Justice Mogoeng. Do you think that narrative has got a basis, Kim, that unless you act against Zuma, albeit that you are an appointee of him, or he, you know, approved your appointment, that all of a sudden there is a question mark about your independence and competence?
Absolutely, and I think history has proved the president correct on so many aspects, and he set up some very good people who have judged against him. You know, interestingly, Shaun Abrahams was also appointed by Sir Ramaphosa, who formed part of the cabinet at that time. And I think we have a very pedestrian view of how these things work. Not that I'm pretending to be a lawyer, I'm not. But I think on the streets of Twitter, we're seeing a lot of legal experts emerge. And Ramaphosa does not have the influence to remove Abrahams. I think that is within the ambit of the courts and a decision to be ratified by Parliament. So I think we must be careful about which facts we're choosing to display and which we aren't. And obviously we're feeding into a narrative against President Zuma. People are so desperate to get for his fall that what we're doing is we're going to find that our legal systems are going to become a casualty of this process, and that has long-term repercussions. I worry that we're going to be setting precedents now that are going to haunt us in time to come because we are so subjective in this narrative.
Yeah, and I mean the erosion of the executive power is very clear, that any judgment is upheld as if it's supreme to what the Constitution says about the president's prerogative and his powers. And for the judge to suggest that just on this particular occasion, Cyril Ramaphosa does not have to be necessarily, you know, take an oath to be a president to exercise this particular function. He just needs to act above the president and then sort of retract, you know, and step back. Is that even practical? I mean, is that constitutionally permissible? Does Zuma have a case to argue?
Look, I think the president does have a case to argue. But from where I'm sitting, we don't know if the president is innocent. But what we know is that the law says that innocent until proven guilty. So, you know, what is evident about the judgment itself is that it was very preemptive, because it gives, or it wants to give a suggestion that the president is guilty. therefore he cannot make such an appointment. You know, it's very preemptive because it then says that because he's conflicted. But who came to the conclusion that the president is conflicted? Was he found guilty by any court of law? No. Doesn't the judgment itself, speak to, the judiciary overstepping its mark, or what in constitutional?
Overreach.
Yes, judicial overreach. You know, one of the things that I said is that one of the problems, one of the mistakes that the government, the ANC-led government, has done is to actually not test some of these decisions in court. But over and above that, we don't have many civil society movements going to court as friends of the court to test some of these cases. I mean, you know, we've seen that Freedom Under Law, your Helen Suzman Foundation, these are the people who are going to court and, and taking some of these cases to court. But there are no other civil society movements who are contesting some of this judgment, because the implication, Cindy, is in fact on the current incumbent of the ANC, the president of the ANC. Now, if this judgment sits, then what happens when Cyril Ramaphosa becomes president? Will it mean, because a president has been said, that a court can then say that you cannot make appointments because you are conflicted? Because we know, for example, that the EFF, opened a case against Ramaphosa in the Marikana case. There are some people who are sending, for example, if you look at some of the references made to the state of capture, they have been saying that Ramaphosa, for example, is captured. We don't know that. But what happens, for example, when it comes, what happens if there is a situation where Ramaphosa is found to be conflicted? Will it mean that, his deputy, if it happens, and I'm just being futuristic here, Didi Mabuza, the court will then say that your deputy must then start making decisions? I think that Ramaphosa as well, the ANC in particular, must be reflective. It must, look at this case to say, what are the future implications? Because it has more bearing, not on Zuma, but the current incumbent of the ANC.
Actually, you're spot on, because even the parliamentarians in the amendments of the rules around impeaching a president, it's not just what happens with a Zuma that is loathed or, hated and so forth, that the incumbent president would have to face the same. It means that we can change our mind about a president. If for whatever reason there's a cloud of suspicion, then we can recall him. That is not how the Constitution was formulated, and we didn't anticipate that this kind of matter will come in. What else would parliamentarians, lawmakers would have to consider in the appointment of the likes of Shaun Abrahams or the NDPP, IPID, all these Section 29 institutions, or Section 29?
Well, I think it's incumbent upon them, as well as the judicial arm and people who serve within that, to make sure that any legal protocols and procedures and principles are upheld without favor or fear, and are not exerted and that are not subject to any political influence by anybody. But I don't think that's what's happening. And I think Papana raises the central point, which is this assumption of guilt before innocence. And that's a narrative that has been traded unfairly in the popular media, but it seems to have now entered the ambit of both Parliament and the judiciary. And that's very dangerous, because what we're doing is we are actually diminishing not only our legal system, but the Constitution itself. And that is why to focus on the short-term maneuver in a very opportunistic and expedient expulsion of the president by whatever means, we're actually causing long-term damage to the democratic organs of the society.
And I mean, try as you may to try, if changing somebody's perception around you or influencing them is very difficult, let alone if you are a public office bearer or you hold a position such as the NDPP, and being conflicted or assumed to be the precedent's keeper, if you like, that even in court papers, citing the history of this particular matter, that there was a Mkotedi Mshe, he had a predecessor that made a particular decision to drop the charges, and after that another process unfolded of trying to have the papers, or rather the charges reinstated. That as a Shaun Abrahams, it doesn't matter what it is that you want to say and prove that you would not necessarily prefer charges against Zuma, or you wouldn't be conflicted. What else must he do to try and instill some level of confidence in the institution?
Yeah. Look, I think another major challenge here is that you've got a legal team representing the president, which I think is dismally failing him. Because, we might want, to put a level of blame on the judge with the assumption that judges understand the law itself. They also understand their parameters or their jurisdiction, as judges. But I think what we continue to see is that, when you look at the lawyers who represent the president, it seems some of them, I don't know, if you listen to them, if you listen to Kemp, it's as if he's, deliberately conceding. And for me, it's a problem. And I think, perhaps the president must interrogate, the legal team that he's given. I think the president must start appointing his own legal team, start paying for his own legal team outside of what the state is giving him. Because his team, the burden of proof lies on his lawyers to actually prove that he's not guilty. We might say all these things, but the burden of proof lies on his lawyers. But I think, for me, on the issue of impeachment, what was critical was what the minority judgment said. I think Mogoeng and his deputy were very clear that what happened with the judgment, it was, a clear case, or, as they said, a textbook case of judicial overreach. But now the problem is that with the Constitution, for example, it's the last point of recourse. You cannot go anywhere else. If judges in the Constitutional Court find you guilty, you don't have any point of recourse. But then there's this minority judgment, which is saying that some of these judges, they are overreaching. They are putting the Constitution in disrepute. And I think that what the president should do, and what other ordinary South Africans who love the Constitution and who want to protect the Constitution must do, is actually, write to the Judicial Service Commission and request for a commission to actually investigate some of these judges. Because, as I said, they are putting the Constitution itself in disrepute, but also the onus of the burden lies on the president to ensure that he's got a legal team which is going to defend him until the bitter end, not this mediocrity that we've seen with some of these lawyers who are misrepresenting him, and where the president and the state is forever losing cases. And we must be honest that,
maybe a sign of a maturing democracy as well, and holding the state accountable, which is a good thing on one hand. And secondly, in the opening the window of opportunity to discuss the Constitution and who it serves best. We've heard of talks that, especially around the land issue, as much as you want to expropriate without compensation, you are bound within the ambit of the law to do it in a particular way. And that has somewhat stalled the whole transition, economic inclusion, etc. Kim, is this perhaps a bigger laying the foundation that we ultimately review the certain elements of the Constitution, including the powers of the president going forward?
Absolutely, and I think your point is very important, and perhaps there needs to be a societal review at the highest level and done very objectively in the interests of the greater good in society of all those things, because perhaps the law has not kept up with some of the contextual challenges, and some have argued that the Constitution as it stands is anti-black, and perhaps that alongside some of the policy frameworks of the ANC, the ruling party, need to be given interrogation. And I think Papana makes some controversial comments, necessary comments about the legal team. But I think we must always, and I don't disagree, but I think the legal team, as any other, the legal team in this case, works in a context of quite a captured narrative. And I'm not sure that they are given ample opportunity to express their views, or that their words come out enough. I mean, we tend to decide who are the heroes in our society and who are the villains. And there's not much talk or criticism of how the mainstream media keep referring to Shaun Abrahams as Shaun the Sheep. So he's villainized, as is the president. And the law, if anything else, should rise above those kind of personal things. And I just want to quote, if I may, just from the president's statement on the state of capture, because it's such a salient message, and I believe this has never really been voiced enough in the media. He said there should be no areas of corruption and culprits spared the extent of the commission. Now, this is not the speak of a man who's trying to hide from the law. This is the speak of a man who's adhering to and respects the law. And I wonder why this kind of verbiage is not given prime position in many of our media houses.
Yeah, the proximity of, let's say, Advocate Mkhwebane and Shaun Abrahams to President Jacob Zuma in support of the extension of the terms of reference, number one, with Shaun Abrahams now also laying his own papers to contest his position, number one, and secondly, as opposed to review that. Do you think that also perpetuates the narrative that indeed they are Zuma puppets, they are essentially taking directive from Zuma?
Well, I don't think so. I mean, if you look at Thuli Madonsela, she was appointed by President Zuma. If you look at Mogoeng, as I've indicated, but. Cindy, I'm saying that black professionals must also test some of these cases. Because we can, sit here and lament and speak of the mainstream media. Indeed, the mainstream media has a particular position. We know that the mainstream media has always, been very subjective when it comes to ANC leaders. But what we also know is that we've got several society movements, white-managed, well-funded, that are taking the ANC-led government to court. Now the question is, where are progressive black lawyers? Where are progressive black lawyers who can take some of, not only in regards to the president, but where are they to take issues, for example, on pro bono? Last year, senior counsel or senior advocates, senior counsel Unterholter was one of the senior counsels who actually took the report or the decision or the recommendation by Mkhwebane, who said that the Reserve Bank or the mandate of the Reserve Bank must be changed. They actually taken Mkhwebane to the Judicial Service Commission. They did not wait for anyone, because they are protecting their own interest. If we agree that the state is captured, why are we not, contesting this in court? So where are progressive lawyers? Where are progressive black lawyers when they can see that the state is captured? By the way, the Constitution itself, there are progressive, clauses within the Constitution, because the Constitution speaks about equality. And we must actually test some of these decisions which are taken, do they speak to the issues or the issues of equality and justice? No, they don't. But why are we not testing some of them?
Papano, we're going to have to take the last, very briefly, last word from Kim in summary, in the sense of where we see this playing out and the courts perhaps being either vindicated or otherwise embarrassed.
Well, I think the laws, the legal courts must treat everyone with fairness. That is the essence of law, and that doesn't seem to be the case. For instance, people readily speak about Zuma puppets, but what about puppets of Ramaphosa? What about puppets of other leaders? So let us not do an injustice, both in terms of the narrative we're following and the legal recourse we pursue.
Ladies, it's been a pleasure. I know you're tempted to get the final last word, Papano, but we're going to have to leave it there. Papano Pasha and Kim Heller, political analyst, joining us in studio. And thanks indeed for watching. We'll take a look at the latest weather and come back with more news and sports updates.